At this time, we're going to consider administrative docket number 495. It's in the matter of the amendment to rules of professional contact 1.2 regarding medical marijuana. It pertains to the petition filed by the State Bar of Nevada on March 11, 2014. We submitted an order setting this hearing today and inviting written comments through May 1st. For the record, we've received 3 written comments. The first one was from Attorney Sean Oliphant on behalf of the City of Reno in favor of the petition filed by the State Bar. Also, Attorney Tisha Black filed written commentary in favor of the petition as well. And Richard Gamick, District Attorney of Washoe County, filed an opposition to the petition. So those are the 3 written comments we've received prior to today. Depending on what happens today, we may extend the written comment time period if people need to provide us some additional information. What we're going to do is allow the State Bar of Nevada to make its presentation, then invite public comment. We're going to limit the public comments to 3 minutes each, not the State Bar's presentation, but any other public comments, just in the interest of time so we can hear from everybody who wants to make comments. And then, as I said, if necessary, we'll extend the time period for written comments so people have an opportunity to say whatever they want to say regarding this particular issue here. We do have speakers here in Carson City as well as at the Regional Justice Center in Las Vegas. We'll start with Carson City. I see Mr. Lefevre here, President of the State Bar of Nevada, Mr. Clark, Counsel for the State Bar of Nevada. So as such, the State Bar of Nevada may proceed with the presentation of its petition.
Mr. Chief Justice, and may it please the Court, my name is Alan Lefevre, State Bar of Nevada. Our presentation can be divided up, me on behalf of the Bar, Mr. Clark on some of the more technical aspects of the rule change and other possibilities that we considered, explored at the time that we filed the petition on the 11th, and subsequent to the education process that we've gone through as we've been trying to keep abreast as to all of these developments. The issue of timing, I think, is very important, and I have asked, and they have been most gracious to come up, Sandra Morgan, the City Attorney of North Las Vegas, Brad Jerbick of the City of Las Vegas, and Mr. Oliphant on behalf of the City of Reno to tell you about the pressing need of the public sector to have legal advice on this matter, and that's why we're urging you to act quickly. As you know, the city charters require, pursuant to state rule, that the city attorneys provide legal advice. And really until the last 2 weeks, I did not appreciate how extensive a role legal advice plays in the various aspects of this very complex area of the law. The range of matters which have been left to local discretion under the state law are considerable, and the public figures, the public officials are relying upon those lawyers for advice every bit along the way. There are various components and moving pieces with regard to zoning, business licensing, and the state certificates, and none of those 3 pieces seem to stay in the same place as they're trying to nail down the next other piece. In the interest of time, too, if you wanted to question the city attorneys, they are highly knowledgeable. In fact, I'm very proud that our governments are represented by people who know so much about this particular area of the law. Our rule change is modest, and as Paul Mattioni reminded me, when this was first brought to the Board of Governors' attention, it was from public lawyers who had indicated some frustration with the process by which the Legal Ethics Committee had been working through an opinion. As you know, that operates separate from the State Bar, and not to preempt its operations, I looked at the Washington State Bar and got a sense from the Board of Governors that they wanted to act pursuant to the requests of public lawyers. We did not process this through for commercial interests, and ultimately there were a couple of the members of the Board of Governors who did not vote because there were commercial interests in their firm, people who had applied for the licenses. The rule change is modest. If we were going to redo anything about this rule, I might add another piece, and that is that lawyers would be expected to educate themselves and advise private clients about the legal consequences under federal law of possible violations of federal law. And I think that's a very, very important piece. Arizona did that recently. I believe it was the 24th of March. They included another line, which Mr. Clark probably has at the tip of his tongue, and that is that lawyers shall take care to advise clients how they may run afoul very easily of the federal law itself. And as you see from the two opinions from the Justice Department, the nuance that's involved in this medicinal aspect. What's interesting about this is that this is not a circumstance in which this court has been thrust into simply by legislative act. This was a vote of the people in 1998 and in 2000, and they enacted a provision to our Constitution which says the legislature shall provide for a law permitting these dispensaries. And 13 years later, our legislature acted. Two senators from different ideologies advanced the bill. It was then sent to the governor after vetting by a legislature with more lawyers in Carson City than we've seen in the distant past. The governor vetted the bill. He's a former attorney general, a former judge who's certainly acquainted with federal law, and he signed it. The other two branches have acted, and they place the membership of the state bar by enacting the law in a position in which there's a clear violation of the rules by public lawyers. Let's set aside commercial interest for a moment. Public lawyers giving advice to their clients which they are legally obligated to give, and the public entities are legally obligated to have them provide input. The process is stymied at the moment. It's unfortunate there are votes being taken, and public city councilmen and women are not having the best legal advice that they can. If there are questions about the peculiarities of the various state subtleties, Mr. Clark is probably better able to handle those. The state of Colorado, which has full legalization, took our same language and put it in a comment 24, and that happened because that court, unlike this one, is much more ideologically driven. That's my take on the proceedings that I've been able to gather. And that court was also possibly concerned that the law might change, or there might be a change in federal law later. I think we have to deal with something up front, and that is that the assumption that this is merely a gateway law and is to be treated with suspicion is not correct. It took 13 years for us to get to the position that the legislature acted. The lawmaking, which is going on the basis of our members legal advice is responsible, is intricate, and at the moment is being fulfilled by law firms from out of state who are advising many of our public entities. And I think to sideline our membership, and especially our public lawyers, is not a responsible thing to do. Thank you.
Questions for Mr. Lefebvre from anybody from the court at this time?
What happens if we don't accept the change?
Lawyers are going to be possibly acting at their peril, and they're going to be stripped of their right to conduct themselves according to their oath. Their oath says they're going to follow the rules of professional responsibility. There's going to be greater reliance on lawyers from out of state. And I think that's unfortunate that public officials in Nevada would have to do that.
Isn't the horse out of the barn already? I noticed from some of the newspaper articles and a lengthy amount of people who have applied for a dispensary and manufacturing and everything else. There seems to be a lot of lawyers involved in that. So, as the law stands now, as the rule stands now, they have violated that rule.
I don't know if they have or not.
They could have. I shouldn't say they have. You're right. It's a possibility. Either as participants in the dispensaries, et cetera, or as advising the many, many LLCs and clients who have applied, over 200 people who have applied. I'm sure some of them have sought legal advice.
Yeah, I'm not a criminal lawyer, as you know, but I would imagine that it really wouldn't be possible. There's no product at play just yet. We're all talking hypothetically. So is there a crime there? There's certainly not one that the federal government is choosing to enforce.
Well, so that everybody understands, and I've heard this from some reliable sources, that the Attorney General, the U.S. Attorney here, Mr. Bogdan, has indicted certain people in grow houses. So, the federal government is not sitting on their hands necessarily if they feel there's a violation of this Schedule I substance. There are some indictments pending that I understand that they're trying to negotiate them with some people who had grow houses.
And I wouldn't doubt that. We're here because of a conundrum which has been exacerbated by the Department of Justice. We have a federal law, and we have directives from the Attorney General in the form of the memos, which place people in very Hobbesian choices. It's not a good situation. We're trying to bring clarity to the situation, not further clouded by operating in this area in which disrespect and the ability to operate in violation of rules is the norm.
I know that our track record in this state, and I was a criminal defense attorney, between the many years of telemarketing where if you represented the client and the U.S. Attorney or the Attorney General or the DA would come and say, if you can give me that lawyer, I can give your client a better deal, if you can give me that lawyer. What we had with the CD litigation and the Homeowners Association and the foreclosure straw parties, I know that U.S. Attorney Bogdan told me that he's convicted over about 15 lawyers of various federal crimes. So our track record on when we go into these new ventures such as telemarketing, construction defect litigation with the Homeowners Association problems, and the foreclosure with some of our friends and colleagues from the bar going to prison, I'm concerned. I just wanted to tell you that.
No, I'm concerned too, but...
and I just wonder if we don't do anything, what do we not accomplish?
Well, you're probably providing ethical lawyers some assurance that they can continue to act ethically. Let's assume that there were no complaints, but they're just a rule. As a lawyer, just like Mr. Jervik, all of us have a right to conduct our lives in accordance with our oath of office and the rules. And right now, we have a legislative act which compels the city attorneys to give legal advice which is arguably in violation of that rule. The state, and as I say, the two other branches have placed us in that position, and the only ones who seem to be at risk right now are the lawyers, and I don't think that's an acceptable choice. I don't think it should continue to be the circumstance, and it should be fixed fairly quickly.
Great. Thank you very much, Mr. Lefevre.
Chief, I have a question, Mr.
Justice Seda.
Knowing the work that the State Bar typically does in preparation or in anticipation of this type of presentation, I assume that you all have reviewed the solution that the State of Arizona has looked at in this regard, where in fact they've just taken it to an ethics committee and suggested that the attorneys can fall within their ethical obligations by simply advising their clients that in fact that the federal law still could be a cause of concern for them. Do you favor that position?
No, I don't. Our process in Nevada is still in its early days, some would say primitive, but the role in other jurisdictions of bar advisory opinions is far more advanced. Now, this court promulgated rules for that body to operate under, and it operates separately from the Board of Governors and from the State Bar and even from Bar Council. So it's a unique entity in creating rules like Arizona, but we haven't gotten to the level of sophistication, for instance, of the New York City Bar Association or those types of organizations. So as a source of law, I think that they are on a lesser plane and really don't provide the assurance and voice that lawyers should have when they're embarking on behavior which arguably violates a rule. So, we thought about that issue, but the only reason that I had put this on the fast burner with the Board of Governors and they chose to react quickly is the fact that the law went into effect on April 1.
Mr. Lefevre, has the bar reviewed opinion statements from other jurisdictions that either have Colorado, California, that have medical marijuana or like, and how that applies to the lawyers?
We have, and what's interesting is that there's almost a dearth of information from California. Mr. Clark and I thought that they would have tons, since it's been 17 years there, and there's virtually nothing from there, or we both need to go back to law school. The Colorado, we did survey, and they did exactly what we did, except put it in a comment. This court has not authorized comments to the rules, so that's why we opted for a rule change. And then the point about the two opinions, Colorado then followed up with a professional opinion, a advisory opinion, and so did Arizona. But as I read our hierarchy of authorities, we haven't quite given the effect that we will someday to advisory opinions issued by that body.
Thank you very much. Does the State Bar have other speakers who would like to present? Say, Mr. Mattioni, come on up and.
Chief Justice, members of the court, thank you for allowing me to speak briefly today on this very important issue. Though I think most of you know me, I'm Paul Mattioni, and I'm a partner in the law firm of Lewis & Rocha, and I'm one of the 4 elected members for Northern Nevada for the State Bar Board of Governors. And I'm here today at the request of the Board of Governors to speak to the court, as we were the group that closely reviewed this matter, and we ultimately determined that it was important to move forward with the petition that's before you. We, as the Board of Governors and the voting members, and it's interesting, President Lefevre had requested that I come up here because the President does not vote generally on many of these issues, and he asked that I come up and I represent that each of the governors in our group discussions looked at this matter thoroughly, and I already hear the court asking, did we look at these various issues? Did we look at what other states are doing? Did we review advisory opinions from other states? We did it with utmost diligence, I can tell you that, and we don't come before you if we did not think this was an important issue. We wanted to move it forward, and as President Lefevre said, there's a timing issue because it's become so important with the cities being tasked with this responsibility to put these ordinances in place to deal with their zoning, with distribution and cultivation, many of the issues that lawyers are generally required to vet and look at. So we, as the Board of Governors and the voting members, we did closely vet this. And really, part of what I wanted to come up here and inform the court is we did look at this very closely. And I think the court has most of that information in front of them. I think that they have the Arizona advisory opinions. They've seen the Colorado comments. And we also took upon ourselves to look at what's been gone forth so far in the state of Nevada. And we did not take lightly the recommendation from the Standing Committee on Ethics and Professional Responsibility, who basically came to us, and I think it's in Exhibit 3 of the materials you have, and the committee said to us, the Board of Governors, you need to revise this professional responsibility provision. You need to bring it before the court, because the way they have looked at it at this point is it is absolutely a violation, and I think that most of us on the Board of Governors agree that without some type of modification to the rule, it looks like there is a violation, and I'm sure that Bar Council will likely agree with me that the way that the rules currently read, that the attorneys are in violation. So it's important for the court to know that we did look at Arizona, Washington, Colorado, everything that's gone on. And perhaps most importantly, we considered the requests. And the requests of our members, the ones that the Board of Governors represent, those are both the formal requests, the multiple informal requests that Bar Council receives for guidance. And the attorneys have told us that they want guidance as to how to proceed in implementing the new medical marijuana provisions and how to provide advice and assistance to their clients in this area without running amiss of their ethical responsibilities. So at least from the position of the governors who sit on the Board of Governors, we felt it was our duty to our members, probably most importantly, including these direct requests for guidance from many of the parties that are here today, the City of Las Vegas, the North Las Vegas, the City of North Las Vegas, City of Reno, City of Henderson. Many of these and many others have felt that the Board of Governors felt it was necessary and it was proper for us to move forward with this petition, bring it to the court's attention. And as the petition indicates, there is a pressing need. That was the language that was used in the petition. There was a pressing need. Local governments and the public are in need of legal assistance in this area. And it's the responsibility of the Nevada Bar to respond ethically. And I thought it was interesting. I saw yesterday in the paper, I just wanted to bring this briefly to the court's attention. There was an article that's been written. It was written in the Las Vegas Review a few days ago, and then it was reprinted again yesterday in the Reno Gazette. So it's both ends of the state. And basically it says that marijuana has gone mainstream. That's the lesson we can take from the outpouring of interest in medical marijuana businesses seen in Clark County. This was out of the Las Vegas Review. A total of 206 proposals were entered by 109 different companies in everything from dispensaries to grow houses to testing labs. And as Justice Chariot indicated, I don't think the horse is out of the barn. I think the door is just barely starting to open. And if we do not step in with our responsibility as attorneys and assist both the public entities and private entities, no one is going to assist them. They'll be on their own. I see attorneys that are backing off, and that's why if you look at the exhibits, many of the city internal attorneys for the public entities are unwilling to assist. They're very uneasy that there is no revision to the current rules of professional conduct, and it's left them in a very uneasy position as to how they should move forward. So really, what we've done is we brought this to the court's attention. We asked for that guidance. We put this together based upon language that we've seen from other jurisdictions. And in order to provide the members of the State Bar of Nevada with some guidance, then we respectfully have requested that the Supreme Court adopt the proposed rule change.
Thank you, Mr. Mattione. Any questions from justices?
I do have a couple.
Justice Hardesty?
Mr. Mattione, the first question I have is the proposed rule change is to 1.2D. In written comments that the court has received from others, it appears as though there may be other rules of professional conduct in our code that would be implicated by this issue. Do you agree? And if so, shouldn't those additional code provisions be identified and amendments to those code provisions also addressed?
Well, it's interesting, Your Honor. I have looked at, as the court's probably aware, and I know they've looked over a lot of these different issues. There have been, in other jurisdictions, they've looked at adopting wholly new regulations. So there's the proposals for 8.6 and some new provisions just dealing as a whole with this issue and trying not to revise the existing rules. To answer your question, Mr. Clark and I have looked at this previously, and I don't think that the effect on those rules justify ignoring or delaying the implementation of this change. I do not see where there is really going to be an overlapping effect. Mr. Clark may have a different opinion, and you may want to ask him, but from my reading, I do not think so, Your Honor.
And then another question I have, in looking at the specific amendment proposed by the State Bar, at least at this point, as far as I know, the only state Supreme Court that has acted on a rule amendment is Colorado.
That's correct.
And the amendment that Colorado enacted is very specific to advice given to the constitutional provisions that permit marijuana use for medical purposes or generally. Our amendment that's proposed by the State Bar seems to be broader. And it reads, as you know, that an attorney would not be violating these rules if they are engaged in conduct, quote, that by virtue of a specific provision of Nevada state law and implementing regulations is either A, permitted, or B, within an affirmative defense to prosecution under state criminal law, solely because that same conduct, standing alone, may violate federal law. What concerns me is the breadth of that language may create unintended consequences. I don't know how many other Nevada state laws may exist that may be in conflict with federal laws. Does this implicate gun laws? Does this implicate other drug laws? Does this implicate trafficking laws associated with children? I don't know how many other laws may be in conflict. So the issue that motivates the rule change is limited, as I understand it, to the question of the constitutional amendment involving medical marijuana. I'm a little bit worried that the breadth of this language gets us really over our skis on unintended consequences. What was the thinking about this language in that regard?
It's an excellent point, Your Honor, and it was, I believe, after the ADTK was presented to the court, that issue did arise with us, because I know that there was a discussion internally about some limiting language, that it be restricted to, I believe, under our Constitution, it's Article 4, Section 38, I think, is the provision that provides for this provision. So I can't say that in some respects I disagree with you, Your Honor. It appears to be the breadth seems to be a little large, and I do agree that I think it was the Colorado court that limited the provision to just this particular section of the Constitution.
So would it be prudent maybe to revisit the breadth of the suggested language from the State Bar in light of this? I mean, as I said, I'm a little bit concerned. We've asked our staff to do some research on, what other potential state and federal law conflicts may exist, but there's some implications here that could result in unintended consequences.
And the only thing I'd respond to that, Your Honor, is we also took a look at that. I can't say that I did it in depth. Maybe Mr. Clark did a little more significant research. I could not find anything directly on point similar to what you're addressing. It does have implications, and I think that's what concerns everyone. There are some implications. I couldn't find anything that I thought was on all four corners directly on point, but I think it is an issue.
Would it be within the State Bar's goal if the court narrowed the focus of the rule change to the issue that gives rise to the rule change?
That was our goal, Your Honor. And if you look at the supporting exhibits, including those from all of the various city entities and others, it's all directed to this rule itself. And my understanding is also the private sector attorneys who are requesting some guidance about implementing the dispensaries and the cultivation issues. So it is directed to this rule. Yes, Your Honor.
Thank you.
Thank you very much, Mr. Mattioni. And I also neglected to mention at the beginning of the presentation, Justice Perigary is not here today, unfortunately, for the conflict, but he will be participating in this resolution of this particular administrative docket.
Thank you.
Thank you. Mr. Clark, we'll hear from you. And I know we have a number of speakers here in both Las Vegas and in Carson City, so we want to give you a chance to speak as well, so we'll try and move things along. Mr. Clark.
Okay. Thank you, Mr. Chief Justice, members of the court. I'm David Clark. I'm Bar Counsel. I am Chief Discipline Counsel for the State Bar. And I'll repeat what's been said before. I'll sort of just cut to the chase and then sort of backfill into that. First, there has never been a discipline case, and under my tutelage there never will be a discipline case against an attorney who gives advice in good faith under AB 74. And in speaking with my colleagues around the country, of the other 21 jurisdictions that have medical marijuana or recreational marijuana, there has never been a discipline case where Bar Counsel has sought discipline against an attorney for good faith compliance with the state law in that regard. I will also say, summing up my conclusion, that in looking at this and looking at the public comments that came in, and I think they add tremendously to the debate and the discussion and the deliberation, in my personal opinion, what may be best served would be sort of to modify the rule change to 1.2 to make it specific to Article 4, Section 38. And then perhaps, in conjunction with that, talk to the standing committee, and I know Alan Freer said he's going to be in Las Vegas, or in the Justice Center, to have the standing committee issue an ethics opinion regarding the need for lawyers in giving advice to a client to make sure that their clients understand the federal contours, the federal ramifications. One, that it's still a federal crime, but two, as the Department of Justice opinions lay out their contours, they have 8 sort of factors that they look at And it's important that attorneys, both in the public sector and the private sector who are advising their clients, make sure that their clients are aware of those 8 goals of the federal government where they will still investigate and prosecute for marijuana, and that their clients and the municipalities tailor their conduct accordingly. So I want to get that up front.
So would you support language, and I recognize Colorado did it by comment rather than rule amendment, but would you in essence endorse the Colorado comment as part of the rule? That seems to me, I'll be direct, the most, the clearest and least dangerous way to go about this, because the rule as worded, the proposed amendment, I share Justice Hardesty's concern with the unintended consequences and its breadth, whereas the Colorado one seems to me to be trying to trim it to the purpose of the rule, which is you can outline, and indeed should as a lawyer, to your clients what the federal laws may be that they're running afoul of and what the state constitutional imperative is on public entities and what the state law allows. So the client's going ahead, eyes wide open. To me, that's almost implicit already in Rule 1.2. And so we're kind of messing it up by putting this text in there that's a bit hard to understand. I think the Colorado approach is pretty well balanced. Long question, but could you answer if that's where you come out?
Yes, I've got the Colorado rule change, and it is an additional comment, and it does specify that validity, scope, and meaning of Article 17, Sections 14 and 16, and may assist the client in that regard. And it goes within these circumstances, the lawyer shall also advise the client regarding related federal law and policy. And speaking as bar counsel, I would support that as well. I think the Justice's concern is correct. You know, don't do the effect of unintended consequences. We made this proposal based on the urgency and the pressing need for a rule change, because otherwise it was chilling the participation by lawyers whose clients really desperately need them at this time, particularly the public lawyers who need them at this time. But I see as the debate has developed, and as Colorado has come down with theirs in March after we filed our ADKT, they limit that language. I think that's a prudent thing to consider. And like I said, maybe added the ethics opinion to say attorneys must specifically counsel their client and get their client's approval or their client's affirmation that they understand that there are federal implications, that there are federal contours to the federal prosecution policy. Because remember that those memos are not written to the public; they're not written to the states. They're written to the U.S. attorneys, saying, "Department of Justice, this is our prosecution posture at this time." But that may change, and it may change with a new U.S. attorney. It may change with a new president. It may change with a new attorney general. But yes, I would support personally for the consideration of that specifying language.
And the assumption is that our rules don't permit the adoption of commentary that's binding to them, and I'd like to ask why and what the source of that belief is.
I don't think there is, well, under...
Like the judicial conduct rules, we have comments that are binding.
In Rule of Professional Conduct 1.0, the Supreme Court has adopted the rules of professional conduct. We did not adopt the preamble or the comments, but they are advisory, at least on the model rule side.
But that's the official commentary. That doesn't stop us from making an official comment.
There's nothing in the rules that prevents you from adding comments.
Right.
Nevada just does not do that at this time.
Well, on that score, Mr. Clark, this issue is, from the point of view of the State Bar and the lawyers who are caught up in it, has some urgency. You've expressed your view as the chief prosecutor for discipline about not pursuing cases on this subject. This issue and rule changes of this magnitude have substantial implications. Why couldn't this court adopt a commentary equivalent to what, or similar to what Colorado did as an interim measure while we continue to study this particular subject?
There's nothing that prevents the court from doing that. I think if the court gives clarity and gives guidance to its members, I think that's the important thing, is to give them some feedback, because that goes into the mix of whether the attorneys are acting with sufficient information to fulfill their ethical obligations. The point the hesitation I have with, it's okay to do it because I say you can do it. Next month I could not be here. And I think
Well, right, but I think if the Supreme Court offers a commentary to Rule 1.2 that is similar to the issue similar to the commentary provided by Colorado, the lawyers can rely on that commentary in interpreting the conduct that's the subject of that rule.
Yes, I think they can rely upon any pronouncement by the Supreme Court in this regard. And if the Court wants to adopt a comment to that, I think that's perfectly fine. That's a guidance to the attorneys. That's a guidance to my office.
This whole subject is evolving. There are many ramifications. We need time to study it. This Court frequently gets pressed to offer same-day service, but it seems to me that it's reasonable to answer this question partially through a comment and then continue to study the rule changes as we progress.
Okay.
Mr. Clark, Justice Hardesty was being kind because quite often we are requested to give drive-through service. And I say that in light of a commentary that seemed to come out today from state gaming, advising individuals not to possibly get involved with the license application if they have a state gaming license. So this is fraught with difficulty as we are advising, say, attorneys to give advice in this minefield. What do we do?
Well, I think the important thing is to give some pronouncement, some guidance to the attorneys that this is where we are at this point, that it's ethical under state law to give your clients advice in this regard, which I think is sorely needed at this point.
Well,
there's a constitutional imperative as well. I mean, that's 13 years ago, the people enacted a law requiring sort of the public accommodate
And now we're
this.
seeing that since the last legislature, this has had a
Yeah,
snowball.
so to me, that, it does demand some urgency.
Well, it's almost silly. The people of this state adopted an amendment to our Constitution. Businesses, the legislature, and others are pursuing various activities based upon those acts. And so because of a professional rule of conduct, we take the lawyers who are going to advise people to get through this process out of the process. That makes no sense at all from my point of view. But I think it carries with it a number of other issues and consequences that need to be evaluated. And so we really do a disservice to the citizens of the state if we take the lawyers out of this issue to advise them on what the law is or could be.
I think Your Honor makes the excellent point that Arizona also echoed. There are critical times when lawyers' advice is truly crucial and necessary, and this is one of those times. It's an evolving landscape of regulation and laws, and we don't want our private citizens, we don't want our municipalities doing this on their own. This is why we have lawyers. This is one of our most crucial
I
purposes.
think it's also a misnomer that because a lawyer gives a client advice about what the consequences are, which could include being prosecuted by the federal government, that somehow we further promote a violation of law. Who's going to tell people, who's going to tell citizens what their risks are if it isn't the attorneys who understand this complicated subject and study it?
Well, I think that's the black letter language of 1.2D says, assist a client in engaging in criminal conduct. And however we slice it, and I tend to disagree with Arizona, as you read the black letter language, it's a federal crime at this point. So it's right there in the rule right now. I agree that the intent is to follow state law, but I think it does need clarification. And I think it needs clarification in the rule, not just clarification from bar counsel's prosecutorial posture.
Well, the reason that I brought up and this was my last question, David, on this point, was whether we looked at other portions of our rules. Let me give you an example. We have a rule that requires one to report potential criminal conduct that our client might engage in, right?
Correct?
Well, if it is the case that a client is going to commit a violation of federal law by engaging in a state-authorized dispensary, is the lawyer who advises the client about how to proceed obligated to notify the United States Attorney's Office that their client is about to engage in the violation of a federal act?
The attorney have the duty to report to the federal government that the
That's
client's
right.
engaged in federal law.
And this is my whole point. I don't want you to answer that question. Our job here is to ask questions. But my point is, this is a very complex area, and it requires that we proceed cautiously and thoughtfully. What is appropriate at this point is whether the lawyers of this state can offer advice to clients who are engaged in consideration of these matters, and the governments who have been charged by the legislature to evaluate regulations and ordinances that implement this. So I think that there's lots of implications for other rules of professional conduct that concern me.
Okay. Another point I wanted to raise, and then I'll wrap up and ask any other questions so we can get on to other speakers, is that the Ethics Committee, the Standing Committee, had also proposed a Rule 8.6 regarding attorneys' personal conduct. Colorado had that proposed 8.6. Their Supreme Court declined to adopt it. I've spoken with Alan Freer and offered my opinion that it's not a necessary rule. 8.6 is not necessary in terms of the attorney's personal conduct, because if perchance the attorney is somehow engaging in this state-sanctioned conduct and gets a federal conviction, as you know, under 8.4, a criminal conviction that reflects adversely on the attorney's fitness to practice. And I think this court has always taken a case-by-case look at convictions. And I think that's important, and that should continue. And that we would look at, any, I guess, hypothetical federal conviction for engaging in personal conduct either through medical marijuana use or through medical marijuana advice to a client on a case-by-case basis. And I think the rules already exist to allow for us to examine that and, if need be, prosecute under disciplinary proceedings, but that 8.6 is not necessary at this time. And I think Colorado agrees with that when their Supreme Court declined to adopt that proposed rule in that jurisdiction.
Mr. Clark, are you aware of whether or not the American Bar Association has weighed in or is considering this issue?
Sorry, who?
American Bar Association.
I have not heard any ABA pronouncements in this regard. I know this is a very hot topic with the National Organization of Bar Council. We're very fast and furious in analyzing this and in working with our jurisdictions to address any need for rule changes, but I'm not aware of any ABA pronouncement in this regard.
Thank you, Mr. Clark, very much. Okay, I know we have a number of speakers here in Carson, which we're going to get to. I see two in Las Vegas. That there may be more, but I see Chris Lawley from the District Attorney's Office and Councilman Coffin from the City of Las Vegas. So perhaps we can get you two up here. Mr. Lawley, did you want to come up, or Councilman Coffin, and make comment? Then we will, I promise, get to everybody here, but we'll move it as expeditiously as possible. Then let them.
Thank you, Your Honor, for recognizing me. I'm Councilman Bob Coffin, spelled C-O-F-F-I-N, in Las Vegas. Thank you for agreeing to allow public testimony on this remedy as chosen by the State Bar. I hope you will approve or construct or modify this amendment to suit your wishes in order that I might have legal counsel as a representative of the public. For 6 months now, I have been out without counsel on this vital issue, which of course creates a lot of angst in the community because this is something that it's controversial, obviously. So naturally, people are nervous and relying upon old information about what should be today's behavior. In any event, regardless of what someone feels about the issue, let me give you a real brief history of what's happened so far in the city of Las Vegas. I don't want to repeat what Councilor Jervik will probably tell you, but I want you to hear him too. First of all, Councilor Jervik and members of his team work directly for the council. They do not work for the city manager. I do not know what the circumstances are in other jurisdictions, but it's a very important distinction to make in this situation because, for example, the city manager cannot go to another attorney on staff and say, well, the city attorney feels that he cannot do this, but will you do it in his stead, or work her way, in her case, down the ladder until we find an attorney who is willing to do this. I've heard the word silly used, and yes, I believe this is silly, it defies common sense, and yet on the other hand, it is important, and it is very real to the attorneys who are concerned about it. Now, let me say that the advice we have received from Mr. Jervik and his team has never been, and nor would it be his place, to say, yes, Councilman, vote for this measure or vote against this measure. His role is only to enable me to make a sensible decision about the language that could be used in two issues, only just two issues, land use and business licensing. That is what was left to the local governments after 374 passed in the last session. I think it is reasonable to allow us to have professional advice. I think we need legal advice. I think if we had lay people in the planning department that were attorneys, but not bar members, of course we could get that kind of advice. But I prefer to have members of the bar in current standing who are privileged to serve in front of all courts. So we need to have, by our side, our legal counsel, and I urge you to, well, I don't want to say anything humorous about this because it's a serious venue, but free the lawyers. After all, you know, everybody deserves a defense, even a politician like Bob Coffin. I've written laws and I've read them, but I never understood them as well as an attorney could. I've worked with many of you on the court on serious issues over the years, nearly 3 decades in Carson City serving in the legislature. I have the honor to serve with you and to work with you and to listen to you. So it's been my privilege now to turn the tables and be speaking to you, making an appeal for your help. On behalf of the city of Las Vegas, that is my plea, and if you have questions, I will stand here as long as you want me to.
Great. Thank you, Councilman. Any questions for Councilman Coffin? Councilman, thank you so much for taking time today and come down and speaking to us. We really appreciate that.
Thank you for allowing me.
Hey, and Mr. Lawley, if you're ready.
Thank you, Mr. Chief Justice. I'm just here observing this afternoon. Thank you.
Thank you. Okay, I know there's probably more in Las Vegas, but we'll if we can go to Carson City here now, and then we'll get back to Las Vegas as well with other speakers. Well, sir, you came up to the why don't you go ahead? You just came up and...
I'm sorry. Chief Justice, members of the Supreme Court, I'm Alan Freer, Chairman of the Standing Committee on Ethics and Professional Responsibility. Just wanted to take a moment to support the positions espoused by the State Bar and by Mr. Clark. The committee's position was attached as Exhibit 3 to the petition. We fully support, there's a little bit difference in the nuance of the language, but we support the State Bar's position. There was a comment, I believe, by Justices Pickering and Hardesty concerning whether or not we should adopt the Colorado position, something similar instead of a rule change. I believe that would be advisable. It's anything to give the lawyers in this state something to go by. The only one distinction I would make with respect to the Colorado language is they specifically limit it to counseling and assisting a client, whereas the State Bar has included a proposal that discusses an attorney's conduct as well. And while Mr. Clark has stated that he does not believe the conduct would reflect upon an attorney's ability to practice, just out of an abundance of caution, I believe that we should also, if we do adopt something similar to Colorado, perhaps include the State Bar's language of also accepting the conduct that's pursuant to the state law as well. And with that, I'll cede any questions that the court has. Otherwise, I'll step aside.
I just, Mrs. Chair, are you comfortable with what Bar Counsel Clark said about the 21 jurisdictions that have either legalized marijuana or medical marijuana, but there's been no ethics charges filed to date? And I know there have been none.
Yes, our committee
if you're comfortable with it. And the reason I say that is because I want to urge everybody of what my colleagues have said about the urgency. We realize there may be an urgency, but we don't want this, as Justice Douglas said, drive-by service, as Justice Hardesty said, one-day service. We'd really like to take a look at this, and we want to make sure there are no unintended consequences, because there are a lot of issues involving federal law, prostitution, gambling, bookmaking, all kinds of things that we got to look at, and to make sure. And as long as and I don't want David to leave because he's my next door neighbor. So David, keep your job, please. He watches over my house when I live here in Carson City. But I want to make sure that Brad and Ms. Douglas and everybody else is comfortable with the fact that we just need some time. And that doesn't mean that you have to stop because you see the direction we're going to go. We just want to do it, but we want to do it correctly. And I want to make sure that my colleagues are all comfortable with what we do.
I have a question.
If I may be so bold to propose that perhaps the court proceed by way of commentary as a stopgap measure that will enable the Ethics Committee to then analyze it and provide further enlightenment with respect to that while further discussion occurs.
I have a specific question that relates to what you said a moment ago about the Nevada proposed amendment, including attorney conduct, where the Colorado comment merely refers to assisting a client in conduct. And I wanted to know what you're trying to capture in the Nevada version of that you think is important and needs to be included. Because the Colorado version does say counsel the client or assist the client in engaging in conduct. So I'm not sure what it is, why you want to import into the Colorado comment the attorney's conduct. Do you follow that?
I do. Most of the focus here is on the public sector attorneys, which is very admirable because without some type of change, we're going to be unable for the local governments to service and implement these rules. With respect to the engaging in conduct, that is more geared towards attorneys that also engage in other practices of law. For example, attorneys that may end up finding themselves as officers and directors of LLCs that operate dispensaries, or, for example, attorneys who happen to be landowners who lease land. That's what the conduct issue was designed to consider.
Okay, that's quite separate from letting the public, drafting a comment that would accommodate the competing constitutional imperative of establishing some means of getting this and your duty to follow the law. That is more of a free pass from the attorney's own self-gain conduct, right?
Yes. And that comes back to a little bit of history with respect to the requests that the committee fielded. We fielded requests from both private sector and public sector attorneys. The private sector attorneys were worried about not only counseling clients who wished to proceed and operate under Nevada law, but also from attorneys who themselves had received requests who wished to operate under the benefit of Nevada law. And that's really a policy decision this court's going to make, but it's something that I wanted to call out so there's no unintended or inadvertent omission.
Thank you, and I appreciate that. On a triage level, and that is a very distinct policy question from the question of counseling a client, at least in my mind.
Justice Hardesty?
Well, on that score, what it sounds to me like is we would be insulating attorneys from professional misconduct charges who engage as a principal in the dispensary or the laboratory. The issue that we're confronted with, it seems to me, is to evaluate whether or not advice and counsel given as a lawyer to a client is going to present a discipline problem. But I don't know that that necessarily should be extended to insulating a lawyer who makes the decision to become a principal in one of these ventures from professional misconduct, at least yet. Is that your point? Is that the essence of the change you're advocating?
I wouldn't say advocate, but calling out is the issue.
Fair enough. I appreciate the point.
But that's originally why the standing committee requested to the State Bar that two changes be made, addition of the Rule 8.6 in addition to the Rule 1.2. The State Bar went forward with just a different version of 1.2, which incorporated the idea of an attorney's conduct in and of itself also to be included as avoiding any type of professional misconduct. Quite frankly, I think both the public and private sector have merit and should be considered, but they are two separate and distinct policy considerations that this court does need to look at.
Well, I think private counsel have the same concerns and issues that public counsel have in advising a client. But my question, I think I get a sense from Justice Pickering's question, is in including the word conduct in the comment that goes broader than what Colorado did, we're addressing a lawyer's participation in a dispensary or a laboratory or one of these other ventures as a principal. I'm not so sure that that is the concern that we should be addressing, at least yet.
I would concede that. The issue primarily is that we need to provide attorneys some sort of guidance to be able to go forward. Sure. And as we stand right now, the decision, the proposed ethics opinion that the committee came up with is that it is a clear violation of the rules of professional conduct in any regard to the extent that it would conflict with federal law.
Okay. Thank you very much, Mr. Fair. Thank you for taking the time. I'm glad you stepped up. We certainly want to give everybody from the State Bar first opportunity to speak today, so thank you for coming up. Mr. Jervik, I know your name's been kind of tossed around here, so why don't we hear from you, and then we'll hear from the city attorneys as well. And I see Senator Segerblum in the back. If he'd like to speak, we'll certainly get to him as well, then, like that.
Chief Justice, members of the court, may it please the court, my name is Brad Jervik in the city of Las Vegas, and I suppose in many ways I'm the reason you're all here today. I wrote a letter in 2013 in October raising this question, and I'm very proud of this court for having this hearing and addressing it head on. Before I talk about the city for a moment, I'd like to answer a couple of Justice Cherry's questions. And the first question I think you asked, Justice, was an intriguing one, which was what happens if you do nothing? I can answer that very bluntly and very directly. One, you heard from Mr. Freer just now, there is a draft opinion from Southern Nevada Disciplinary saying this is an absolute violation of the rule as it's currently written. The direct result will be no Nevada lawyer will be ethically allowed to participate in advising clients on medical marijuana, dispensaries, cultivation, distribution, or anything, in spite of the fact there's been 2 votes of the people to amend the Constitution, in spite of the fact the state legislature adopted SB 374, in spite of the fact that our governor signed it into law. That will be consequence number 1.
But don't you take an oath to support the Constitution of Nevada?
We do. But when I get an opinion from state ethics saying it's a violation, that's what I'm going to follow, and that's what every attorney is going to follow.
More than the Constitution of the state.
I don't think that the rule right now is sophisticated enough to draw a distinction between a conflict in the federal law and state law, whether it's Constitution or state law. I'm sworn to uphold an oath to uphold the Constitution of the United States, the laws of the state of Nevada, the laws of the city of Las Vegas. And that doesn't always take into account these conflicts. And this is a very, very unique conflict. Remember what got us here. What got us here, and when you say nobody's been disciplined yet, nobody's been the subject of it, this is fresh. This isn't even a year old yet. The original letter, authored by Deputy Attorney General Holder's assistant, called the Ogden letter, was 2009. And that letter was so oblique, another Deputy Attorney General, Cole, felt obligated to clarify it. And that clarification was so unclarified, he felt the need in 2013 to clarify it again. So we're operating on relatively new stuff that was just issued by an unappointed member of a presidential cabinet, which could change overnight.
But do you understand what my colleagues have said about the urgency? If we just jump into this, Mr. Jervik, we don't know what we're frightened about just jumping into something.
That's
We're all
my next-
hesitant about that. We want to take our time, and we still want you to advise our city. You know, I live in the city of Las Vegas and the city and Carson City, but I want you to be able to advise Coffin and the rest of the council people. And I see that a lot of action is taking place. I watched it on the TV, your city TV station, where the planning guy gets up, and the room was filled with people, and they had a bunch of questions, and some of them were attorneys who were asking questions. And I want Brad. I know Brad. Brad, I've known you since you started practicing law. That's what happens when you're the oldest one on the Supreme Court. You see everybody come in. And I want to make sure that you advise our council people, and our friend from North Las Vegas, and our friend from Reno. I want to make sure that you guys are comfortable. But also I want to make sure my colleagues are comfortable in what they decide. We've already got an issue now with what Justice Hardesty raised about people who are participants, principals, as opposed to somebody like you. You know, you should be protected. I don't think anything's going to ever happen to you, Brad Jervik. You are an ethical lawyer. You've been your whole career. And I think that I'm hoping that maybe we can resolve this, but we need some time. I think that's what my colleagues are saying.
I appreciate that. Let me just say the only thing I wanted to start with is, let's start in reverse order. What happens if you do nothing? We will be moribund. We will not be able to advise. This opinion will come down. So then the next question is, what do you do short of nothing? And of course, one option is what's on the table right now that the Nevada State Bar put before you. And I can appreciate the trepidation of this court. If you feel that there are unintended consequences that would result of adopting this, we don't have any objection, as I don't think anybody in this room has any objection to your modifying it to be a comment or to be a redacted rule change, as long as it gets us where we need to be, and that is to be able to give ethical advice to our clients without going further than that. We don't want to violate other federal laws. But Justice Hardesty, to be honest, I listened to your question about this other bar rule about turning yourself in. The comment would have the same result. It would be the same question. Do you turn yourself in? Whether you do it in comment form or you do it in direct language form, that still remains. And I don't envy the fact that you're going to have to struggle with that as you debate these comments when you retire.
I guess the point, Mr. Jervik, is I'm not sure we have, and this is no criticism of the bar or anybody who's evaluating it. It is a fact that this is a complex issue, and it comes to all of us, as you point out, in a very fresh way. So the full extent of implications have not been evaluated. My questions and others' questions just point this out. But I think as we study this, we can provide some interim relief that makes sense and allows the citizens of this state and the governments of this state to receive advice, legal advice, from who they should get it from, Nevada lawyers.
I appreciate it, Justice. What I would pray is for some relief that maybe strikes a compromise. Let me explain why. One, as you probably have read, every governmental entity is treating this somewhat differently. The county has already adopted ordinances dealing with the zoning end of medical marijuana dispensaries, cultivation, distribution, and they today took a vote to decide how many licenses they would be eligible for, and they are taking applications. The state has applications for certificates, and they're taking those applications soon. The city is scheduled to introduce an ordinance tomorrow to deal with the zoning aspect only of medical marijuana that will be eligible for adoption on May 21st. And because I think North Las Vegas is right behind us, and I won't speak for Henderson, but we're in the middle of this, and one of the things that has happened is this suggestion that if you don't jump in and have these ordinances ready, you may lose any opportunity for your local municipality or county to be involved in it. And so we're not moving because of no reason at all. We're moving because we're being driven by a timeline that was set by the state, set by these agencies, and we're there right now. What I would suggest as a middle ground based on that fact is if you feel comfortable giving us some short-term relief as quickly as possible, we would all be very grateful. I would urge when you craft that short-term relief, if you're at all disposed to go that route, keep in mind we're not advising on the Nevada Constitution. The only advice we would ever give on the Nevada Constitution is the state legislature pass a law. That's all the Nevada Constitution says. We would be advising on state law, not only as it exists today, but may be amended because of things that come up in the next few months or years that require amendment. So that's what we would be asking for, is permission to do that, even if those state laws are in conflict with federal law. And I agree with State Bar Council and with Mr. Lefevre that if you want to include in that a requirement that we also advise as to the risks and the disadvantages, we will do that anyway. But I think that that's appropriate. I think we need to tell our clients this remains a federal law, and as long as it remains a federal law, there is always risk that the future may change, these letters may go away, and somebody may look at this differently. A simple
How would
change
you
like that.
define the law that you would like to counsel your clients on? Say we did a very specific comment and authorized that lawyers can advise clients with respect to XYZ. What would be XYZ?
I would answer that question, but keep in mind, I'm only answering for myself because I don't know what the broadest things I can imagine my counsel engaging in would be everything state law allows them to do. And that would be cultivation, distribution, production, that would be locations, that would be taxes, that would be regulation, that would be many things I probably can't even think of. But I would say, to be honest with you, Justice, because if you tailor it to what I'm about to answer, you may not answer it for my good friend, my colleague in North Las Vegas. And so I would say, to the extent that Nevada law addresses the constitutional mandate as written today or in the future, that would be my request.
Thank you.
Thank you so much, Mr. Gerber. Thank you for
so much for your
coming
time.
to Carson City. Ms. Morgan from the City of North Las Vegas.
Good afternoon, Chief Justice and members of the court. May it please the court, I'm Sandra Douglas Morgan, the City Attorney for the City of North Las Vegas. Of course, I want to echo all of my colleagues' comments, Mr. Gerber from the City of Las Vegas, and of course the comments of Mr. Lefevre and Mr. Clark. The statutory scheme in NRS 453 actually requires local governments to draft ordinances related to zoning and business licensing. It is my job as City Attorney to actually advise the council on the constitutionality of those ordinances. We are a couple of weeks behind Las Vegas, but we have a special city council meeting tomorrow, and our planning commission is reviewing the zoning regulations next week. And I've been talking to them about the ordinances, but I haven't made any comments publicly because I'm waiting for this rule change. So any guidance that you can give myself, I know my colleagues over at the City of Henderson had some concerns as well. It would just be very beneficial to all public attorneys in the state of Nevada.
Any questions for Ms. Morgan, please? Thank you so much for coming up. We have a representative from the City of Reno, too. Council, if you'd like to come on up. And
Good afternoon, Mr. Chief Justice, members of the court. May it please the court. My name is Sean Oliphant, and I've been retained by the City of Reno to represent them through this proceeding, and if the rules are changed, to help advise them with regards to the medical marijuana law in Nevada. It's good that we've had public comment on this because it has flushed out many of the issues. The reason that the urgency exists is because the state legislature required the Health Division to adopt regulations by April 1st, and that was done. And part of those regulations and part of the law is that establishments cannot be licensed or even are supposed to not be able to submit applications unless they have letters from the local jurisdictions saying they're complying with all laws, and two, that they have a business license. So that process now, the local jurisdiction is the cog in the wheel keeping the law from being implemented. So all of the jurisdictions, including the City of Reno, are now drafting ordinances. Staff is drafting them without the benefit of counsel, because if no rule change is made, according to the Standing Committee's opinion, there's a violation of Rule 1.2D if you counsel your client with regards to ordinances for medical marijuana use. So if there is no change, we have one of three things. We have ordinances being drafted by staff without any legal guidance whatsoever from Nevada attorneys. You have attorneys in Nevada who can unethically advise against the rule and take the risk. Or three, you have out-of-state attorneys who are practicing law in the state of Nevada, potentially, without a license to do so. So that is the reason that the urgency.
Well, that issue has come up earlier, and I want to comment about that. what's with lawyers coming in from out of state and advising local governments about this law when local lawyers can't do it? I hope Mr. Clark's looking at that. I mean, I don't think number 3 is a solution, and I appreciate your input, Mr. Oliphant. I've heard this 3 times now. I'm thinking to myself, where is the authority for that? And lawyers who want to come in and poach in Nevada and start advising on medical marijuana when the Nevada lawyers can't, probably do so with other risks.
So obviously, there are a lot of issues to flesh out. You just touched on the surface of some of them. The local jurisdictions and the establishments who will be running these operations no doubt will need legal counsel as long as they're operating, and there'll be changes to ordinances that will need to be made. But right now, we're not able to advise the city staff or city council on how they can comply with Nevada law, and at the same time risk enforcement by the federal law by establishing and promoting the 8 priorities that the federal government has come down to leave the enforcement of marijuana laws to the state. And I think that's really when you discuss advising counsel, when you advise them as to federal law, I think not only do you have to advise them that it is, marijuana is a controlled blood substance under the CSA, but you also have to advise of the memorandums and the current enforcement procedures. And that memorandum with robust, efficient regulation and enforcement may very well promote those 8 priorities the federal government is looking to promote. One of the things that they've said is if you establish robust enforcement and procedures to manage this, then we're going to leave it up to state law. And really, if you're looking at medical marijuana and having medical people or medical patients who need the marijuana or have a prescription for it, then you take them from getting marijuana off the street to a licensed organization where everything is regulated. So, if that is adopted and you're counseling your client as to that, you actually could help with enforcement of those 8 priorities. Be happy to take any questions. The City of Reno is also meeting tomorrow with the Planning Commission, moving forward with ordinances, which I have not reviewed at this time because of the opinion and Rule 1.2D. So a comment similar to Colorado's that could be issued quickly would help all the jurisdictions to have legal guidance when these ordinances are drafted.
Thank you so much, Mr. Oliphant, as well. And thank you for your written comments as well that you submitted to the court. In Carson City, do we have any representatives from any of the city municipalities or county entities, any county? Then I'll go to Las Vegas. Do we have any other city representatives or county representatives? Councilman Coffin, you have something else you wanted to add?
Your Honor, and forgive me for approaching one more time. 2 things I forgot to tell you. I am the sponsor of the legislation which will be introduced tomorrow morning, 9 a.m. in Las Vegas, to introduce the bill which will control zoning. It's going to be amended heavily, but it has to be done on our schedule, which will conform with the state's schedule by the 21st of May. So introduction on May 7th, passage on May 21. On May 21, we will be introducing legislation for the licensing component of this procedure in the ordinances. And so that all has to be done on the timetable of June 2nd. I forgot to mention that earlier, I'm sorry. Regarding the subject of out-of-state counsel, the city manager has hired out-of-state counsel to look at our land use and licensing work so far done by our staff without the benefit of Nevada counsel. Now, Colorado is full of attorneys who know this stuff, and that's where this attorney is from. I can't think of the name right now. I've never talked to him, but we're having to use him. It would make sense, I suppose, in a state that's gone as far as Colorado. So that's all I had to add to the record, Your Honor.
Great. Thank you, Councilman. And again, we still have all our state bar representatives here. I'm sure they're interested in that point you just made. Senator Siegerblum, did you wish to address the court?
It's my senator.
Oh, okay. We have a couple of your constituents.
After that, I'll be real quick, but I would just say, in response to your your comment, Justice Cherry, that the horse is out of the barn. This thing has taken off unbelievably. I don't think anyone appreciated what was going to happen here, but 2 weeks ago I met with the head of the marijuana division of Lytle, Sawyer & Collins. I mean, law firms throughout Nevada are accepting these cases. They're making huge fees. The real estate market in places like North Las Vegas, where they have huge warehouses, has gone up. I mean, there's 200 applications. Everybody paid $5,000 for each application. That's $1 million that the county just got in fees just to apply. And then the state, of course, they're going to get all this. I mean, it's a national thing. It's going, and so I appreciate the desire to go slow, but please go. I mean, it's taking off.
As a lawyer, Senator, how could we help Ms. Morgan and Mr. Jervik in this situation, especially because I just can't comprehend our municipalities not having legal counsel of our own legal counsel.
Well, I would look to Mr. Jervik's comment, but if there's any way you could quickly issue some type of a letter or a comment or something, just saying, from our perspective, this is okay, then they can go forward in this initial process because everything is under the gun. The state's applications are probably going to be accepted the 1st of August. Those applications, if you're going to apply, you have to have some approval from a local government. So some of these local governments will lose their rights if they don't move quickly.
And the implementing legislation is all in Chapter 453?
I believe so.
Okay, you're not.
I just know SB 374, but it's.
Okay.
But yeah, it's there. But if anything you can do to just clarify that process, then take longer time for these other issues. But also the initiative is out there. They're already getting signatures for something which will come to the legislature next February and probably on the ballot in 2016. So this is not going away. This is a huge issue that nobody, including myself, could have predicted.
And is it correct that there are over 5,000 medical marijuana card holders in the state of Nevada?
There are, but there will be 50,000 a year from now. And we also have reciprocity with other states. California has 1 million.
And you're familiar with the fact that our federal government, our U.S. attorney, has indicted some people from the grow houses when they were unable to get
Yeah, I mean, if they take it our law and like several people will go together and say we're going to combine the things and they're being prosecuted. I actually know a lawyer whose husband is being prosecuted.
I know that same lawyer.
Yeah, yeah. I mean, it's incredible.
And her son also.
Yeah. So I mean, it's a tragic thing. Hopefully, we can work on the criminal side of it too next session to reduce some of the penalties and do some stuff. But
are you in touch with the U.S. Attorney Bogdan to give some assurance to our local attorneys that are not our attorneys, but the people, our folks that are involved in dispensaries, et cetera?
I was present during the conversation, and he is monitoring the law. He was not fully aware of how fast we've gone, though. So, but I think he's paying more attention to it. But it's, I mean, the U.S. Attorney Attorney General, I mean, is laid out. If there's a tight, regulated scheme by the state, then they're going to basically stand back. But again, that could change. But anyway, it's just there's lots going on, and I know you got a jillion things on your mind, but please make this one of them.
Senator Segerblum, you talk about hurrying, but I'm concerned, and I say that without any reservation. I'm looking at this August 29th, 2013 letter from Department of Justice, and the first bullet point down about what they're concerned with is preventing the distribution of marijuana to minors. And in the context of medical marijuana, I've seen things on television that can be very beneficial.
Our state law allows it for minors. Yeah, a minor can get a prescription.
So we have some kind of limiting language as to minors. All right, thank you.
Thank you, Senator, for coming up to Carson to speak to us today. Do we have any other speakers here in Carson City that would like to address the court on this issue? Okay, if not, we'll go to Las Vegas. I don't know if we have anybody else in Las Vegas. If you would like to speak, would you please approach the bench and state your name for the record, please?
No, I believe that's it, Chief.
Thank you, Myrna, for giving us. So, okay, any other questions or comments from any of the justices before we conclude the hearing today? Okay. Anything else any justices would like to make? If not, we appreciate all the comments. We appreciate the timing issues raised by everybody here, and we will take this matter under submission at this time.